Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill Obrien. He's also your host for this continuing conversation. Here he is now, Dr. Bill Obrien.
Thank you, Agnes, and welcome to the Virtual Center for Study of the Constitution and Civic. I didn't even know what we were doing here. I mean, that's how long it's been since I've been on, it seems. But anyway, welcome to this Wednesday edition of the Virtual Center. Today is the 5th day of September in the year 2018. It is a Wednesday, as I mentioned, and I do apologize. This is our first live program this week. Monday, because it was Labor Day, Bob and I chatted and decided it might be a good idea to forego the program on Monday. Then yesterday I had a medical appointment, a doctor's appointment. I had to have an x-ray. It wasn't of my brain, however. That would be a waste of time. So this was a chest x-ray. But I have a doctor's appointment one day next week. It's not going to interfere with the program. It's Thursday. But my doctor asked me to get a chest x-ray about a week before I came so that he would have the results when I did come. So I went out, I scheduled it, and it was yesterday. And so today is our first day of the week. And of course, given our schedule, it's our last day of the week. So I really do apologize for that. But I don't know, it just seems like things happen to all of us. And in a program like this, I mean, it's not just me. It takes a number of us to bring this to get this program on the air. And if anything happens to any of us, obviously the program, has to be postponed. But welcome to today's program. We do invite your comments on issues of the day, and of course there are two major ones that have happened since last we were together. One, of course, is the beginning of the Brett Kavanaugh hearings, or as I called them, I made a kind of a sarcastic comment in class this morning, called it the judicial follies, because yesterday was absurd. And today, of course, is a little bit absurd as well. It's an artificial proceeding. In fact, there was a comment by one of the commentators this morning, which I thought was pretty telling. And it was there were about 11 undecided senators in this nomination. Everybody else has already decided how they're going to vote. So it's pretty obvious. And I thought it was interesting because at the end of the day yesterday, after several hours of demonstrations and shouts from the audience and people being escorted from the chamber and all of these other things, the nominee Brett Kavanaugh was given an opportunity to make his opening statement. One of the things he said was that under no conditions the last thing we want to see is for the process of judicial appointments to be political. I mean, given the fact that this followed on more than 6 hours of absurdity, was almost, it was almost something you could expect to see on Stephen Colbert, rather than on the floor of a hearing of the United States senators. But anyway, so that's one of the issues that has occurred. And the second one, of course, is CNN and the Wall Street not the Wall Street, I was going to say Wall Street Journal, Washington Post ability to get advance copies of a book that's scheduled to come out on September 11th, interestingly enough, which is next Thursday, on President Trump. And unlike some of the other books that have been attacked as being not valid and a lot of speculation and all of that, this one carries the label of valid because of the author. And and this one is getting a real reaction. We'll talk about it in a moment. But first, I wanted to share with you our phone numbers and encourage you to participate in our program by sharing your thoughts with not only with me, but with our other listeners as well. If you are a regular user of Skype, you can just go on Skype and type in Bob Kincaid Horn, Horn, and that will get you, that will be a direct line into the Head On Radio Network studios, and Agnes is there today, and she will get you on the air immediately. Or if you'd rather, you can dial directly on your phone into the studios. We have two numbers, either one of which will work. The number that we've had for some time is area code 304-574-8178. 304-574-8178. Bob informed us last week that during a recent shutdown, he was able to come up with a second direct line into the studios. Area code 304, same area code, 640-2829. 640-2829. Those are obviously the most direct and immediate ways to come on the air and share your thoughts with us. But we do have other ways that you can communicate, and they don't require that you come on the air live. You can email me directly and trust me to get your thoughts on the air for you. You can send me an email at waobrien906@gmail.com. That's waobrien, Obrien 906@gmail.com. And yet a third way that you can communicate with us is on our Facebook page. If you go to Facebook, the homepage, facebook.com, in the search box at the top, just type in the Virtual Center for Study of the Constitution, and you'll be onto our Facebook page. And there are a number of postings there. I'm going to make reference to one of them in a moment. And after each posting, there's a comment box. And if you click on that button, that comment button, you can make a comment on that particular posting, which is the assumption of the box to begin with, but you can use it just to communicate directly with me and make reference to any other issues related to the program that you would like to raise, and then make your comment, and I will get notice of the comment. It'll come directly to me, and then if it does seem appropriate for our other listeners, I'd be glad to share your comments with our listeners on the air for you. But again, the most immediate way is to just come directly on the program and basically make your points yourself. And we do encourage you to do that. I did mention the issues of the day, the two major issues of the day, of course, being the Brett Kavanaugh confirmation hearings and Bob Woodward's latest book on Trump, which is scheduled to be published on the 11th, which is next Thursday, a week from tomorrow. But it's getting plenty of attention now, and it's getting plenty of reaction. Many of the comments in the book are shocking. The irony of the situation is, and Agnes and I were just chatting before we came on the air about this. If you remember, not too long ago, Wolf's book came out and said many of the same things and shared many of the same stories. People felt much more comfortable in downplaying the validity of Wolf's book, challenging it in many ways by saying his principal objective was to sell books, et cetera, et cetera. There was no way to verify. Some of these things were so outlandishly shocking that they probably were made up and not real, et cetera, et cetera, et cetera. Now, several months later, along comes Bob Woodward's book. And again, the significant issue here is the author, Bob Woodward. He has a reputation as for being a meticulous journalist. And as you know, along with Bernstein, he was instrumental in undoing the presidency of Richard Nixon in uncovering Watergate. Woodward has received 2 Pulitzer Prizes. Even those who don't like what he says in this book, assuming that what we're getting on the book is accurate, and of course it's not going to be published for another 8 days, or 7 days, I guess it is, 7 or 8. But the fact of the matter is, Woodward's reputation is impeccable. And Woodward has a reputation for putting everything on tape. All of his interviews are on tape. He has extensively interviewed people in the White House, people who were in the White House, and as we know, that's a pretty hefty list, because there are a number of people who were in this White House who are no longer in this White House. So the cast of characters is pretty significantly large. But apparently Woodward talked to many or most of them, and word has it, if Woodward holds true to form, he's got tapes of many of these interviews. So even though some of the people quoted are denying they said what the book says they said, the fact of the matter is there's a question, because there's an inclination, all things being equal, to support Woodward over the denials of some of the people who uttered some of these unbelievable statements about President Trump. My heavens. I got to tell you where the comment, where the slip of the tongue with President Bush came from. This morning when I went in to teach my class, I went into my office and there was a book on my desk. I didn't know where it came from. It was just there. And it was a book written in the 3rd year of George W. Bush's presidency. It was by John Podorentz. And it was a book about how Bush's presidency was so successful in its first 3 years that it was driving liberals nuts. And somebody on staff saw the book. Apparently it was in a pile of books that was there for the taking. Saw this and thought I would love it, and took the book and basically stuck it on my desk. And that happened this morning. And the person who gave it to me came by and said, "How'd you like the book I left on your desk?" So at least I know where it came from. But and I've had that on my mind this morning, so that I think that's probably why I misspoke and mentioned Bush rather than Trump. But the fact of the matter is, basically what the overall gist of the book suggests is that much of what we've been reading and hearing is on target. In other words, there aren't that many surprises in the book. It basically speaks to an administration that, as one person said, seems to be coming apart at the seams. It suggests that many of the people closest to this president are claiming that the reason they are staying in their positions is because they feel that they have a duty to protect the nation from the president. There's validation of that associated with the names Mattis, Kelly, McMaster, Cohn, and many of the people who have left the president's administration, as well as many of those who are still there. The fact of the matter is, the book opens, according to the excerpts that have been released, with a story of Gary Cohn, former economic advisor to President Bush, off the president's desk and hustling away with it before the president had a chance to sign it. It related to a trade deal with South Korea. And Cohn's concern was that this document, if the president were to sign it and it became policy, could do serious security damage to the country, because it was aimed at South Korea based on the president's assumptions that everybody we've been involved with in trade has been taking advantage of us until now, until the president has eliminated many of the deals which have been treating us like the piggy bank that everybody robs. This particular document would have retaliated against South Korea to the point that it would have jeopardized our security. So Cohn removed it from the president's desk, hoping that the president would not miss it, and he didn't. That's the beginning of the book. The end of the book is a statement by, I believe, John Kelly. And according to the reports, the last line in the book is a quote from Kelly to the president, which basically states straight up, "You are an effing liar." The implication, the context being, everybody knows you are, and I'm telling you you are. And part of the reason and part of the issues related to this is the Russia investigation and the president's obsession with that investigation. The stories are incredible. The conclusions are frightening. While Mattis and Kelly deny this, Woodward reports willingness to sit down and be interviewed by the special counsel Robert Mueller seems to be a dominant theme throughout the book. The degree to which the president's advisors and staff are determined that he should not sit for such an interview because he will more than likely perjure himself and commit a crime. And according to Woodward, there's a story where his attorneys, Dowd, who has since left the White House, and Jay Sekulow, who's still there, engaged with the president in a mock interview on the Russia investigation. The idea was to demonstrate to the president how difficult such a one-on-one with the special counsel would be and how unprepared for it the president would be. It was a skull session, a practice session, if you will. According to the reports, it went on for about 30 minutes, during which time President Trump was unable to resist lying, fabricating, adding to truth to the point that it became untruth. In other words, he failed the test miserably. And according to the reports, according to Woodward, his attorney, John Dowd, made the comment and said, "This is a perfect indication as to why, Mr. President, you can't go and give in, sit for this interview. You should not go. It's either that or an orange jumpsuit for you." In other words, if you do sit down with the special counsel, you're going to be convicted of a crime because you can't resist lying. And then at the very end of the book, the comment is made, "You are an effing liar." We've heard this all the way through from numbers of different sources. We've seen all sorts of evidence in the media about the degree and the extent to which the president continually, regularly lies. But here are the people closest to him who not only are attesting that it's a fact, but are attesting even further that the president can't not lie, that the president cannot tell the truth. The most frightening thing to me about the book, one of the most frightening things, excuse me, had a cough break there. One of the most frightening things about the book to me is the fact that people closest to the President of the United States know what they're dealing with and are trying to adjust to it. It's amazing to me that many of the things that have been alleged by people who believe that President Trump ought to be removed from office, that he's not fit to serve. Now we know that the people closest to him believe the same thing. So what they are doing is doing the very best they can to shield us from him. That is an absolutely incredible statement if you think about it. But there's even more. This, to me, is the most astounding thing that I've heard about the book so far, other than some of the language. The uses of the term dumbbell and liar and stupid and moron and idiot and all these other things that we hear about the President of the United States. I have to keep adding that because I find it difficult to believe that it's the President we're talking about here. But according to Woodward's book, after this mock interview with the President, Dowd and Sekulow contacted Mueller, contacted the special counsel. And basically what they did to the special counsel is make the special counsel aware of the mock interview that they did with the president so that he would see why we can't let the president come here. And basically what they said is he can't keep from lying. He can't tell the truth. His testimony, the interview would be worthwhile because you never know what to believe and what not to believe. You wouldn't be getting any valid information from it. All you'd be doing is validating what we're telling you right now. And Mueller's response to these two attorneys of the president was, I understand, I know. To me, it was incredible that the special counsel knows what we're dealing with and what these advisors and people in the White House are attempting to deal with on a daily basis. We're in trouble. I guess that's the thing that bothers me the most about this. I'll be honest with you, I don't see a whole lot that's new from what Wolf wrote several months ago. The difference is because it's Bob Woodward saying it, it kind of validates many of the things that people questioned when Wolf said them. If anything, Woodward has provided the kind of hard evidence that makes this a frightening situation. And of course, the first question that we have to ask, how long can this go on? How long before something bad happens? That's what frightens me. How long are the president's most ardent supporters going to run interference and provide cover for him? How long? And that, it seems to me, leads us directly into the other event of the day, of the week, if you will, which is the Kavanaugh confirmation hearings. I made a few comments at the beginning about yesterday's opening session where each senator was given 10 minutes to make a statement. And the reality turned out that many of them took more than 10 minutes. And chair of the Judiciary Committee, Chuck Grassley of Iowa, made in one statement at one point during yesterday's charade, made the point that if you don't control the hearing controls you. And he said, unfortunately, I let the hearing control me. Basically, what he was saying is, now that I've let so many of the speakers go more than 10 minutes, I can't suddenly begin to enforce the 10-minute limit on any senator's time. But the fact of the matter is, there were, according to reports, 63 people removed from the chamber for shouting out or doing something else to create a scene, holding up signs or whatever. It is also true that Brett Kavanaugh's two daughters, young daughters, I think they're 10 and 13, if I'm not mistaken, were escorted from the chambers. He brought them to the chamber so that they could see the Senate of the United States in action. And once they began to get a glimpse of the Senate in action, the decision was made for their own best interest to remove them from the chamber. And of course, depending on who you read, it was either the Democrats' fault that the thing turned into a travesty, or it was the Republicans' fault. I've made it a regular practice, and it's been a practice of mine for all along. But recently, I've made it a more intent practice. When I look at the internet each morning, I've developed a habit of going to the Washington Post and then directly to the Washington Times. The Washington Times is the conservative daily in Washington, D.C. The Post is the more liberal paper. Because it's very interesting to look at the news of the day, especially where it's Washington's news of the day, from the two ideological perspectives together. And it was very interesting this morning because obviously the lead item was the Kavanaugh hearings. The Woodward's book was kind of the second item on the front page of both papers. But the thing I noticed, predictably of course, is that the Washington Times blamed the chaos on the Democrats. The Washington Post assigned responsibility exclusively to Republicans. It seems to be, it give us insight into the degree and nature of the partisanship that engulfs this country. I haven't heard but one person make this point. I'm probably missing somebody. But with one exception, I haven't heard anybody take yesterday's hearing and hold it up against the week of John McCain that the nation just went through. It seems to me that the better than 6 hours of absurdity that seemed to dominate the Senate hearings yesterday on Brett Kavanaugh, when held up against the week of celebration for the life and heroism of John McCain, creates the kind of stark contrast that few have commented on. There was one article this morning which made reference to the fact that yesterday was an indication that the idealism and hope that many people took from the week of celebrating the life and patriotism of John McCain wasn't going to have the kind of lasting impact that many of us hoped it would have. After a full week of tributes to John McCain, many people, many optimists, began to think positively. Maybe McCain's message is going to get through. It's so powerful. Maybe some people will begin to change. And as you thought back to the week, certain images began to fix themselves in my mind at least. I saw Mitch McConnell and Elaine Chao, his wife, sitting in the front row with Chuck Schumer. I saw Paul Ryan there. I saw Dick Cheney and Lynn Cheney sitting with Al Gore. I saw the Bushes sitting with the Obamas and the Clintons. And one began to appreciate the detail with which John McCain planned every event for the week of his death, the week after his death. He arranged who should be sitting near whom. He arranged who spoke before and after whom. And you couldn't help, by the end of the week, to begin to believe that some of it was sticking. Some of the statements by Lindsey Graham, for example, Jeff Flake, you began to get a sense that many of these people were beginning to take to heart some of the things that John McCain had said on the floor of the Senate and in other places as well. McCain's last speech on the floor of the Senate, if you'll remember, when he made the statement in the Senate, we're not getting anything done. All we're doing is looking for scapegoats to blame the fact that we're not getting anything done. It's broken. We're doing a disservice to the nation, to the founders, to the people of this nation. And I guess all of us wanted to believe that some of that would get through. For those of us who thought that it might, yesterday's Brett Kavanaugh hearings was kind of a crash course in reality. I couldn't wait to hear Lindsey Graham yesterday. I couldn't wait to hear Jeff Flake yesterday. Turns out at the end of the day that the one 10 minutes plus speech that at the end of the day I realized I really couldn't get along without was the statement by Sheldon Whitehouse, Democratic senator from Rhode Island. It was incredible. I hope after a little bit of time, 24 hours or so, that I'll be able to go online and get verbatim statements of the comments that each of these senators made, because I want to keep White House's statement. It was so powerful. I was extremely impressed. Not only that, but early last evening, during the Meet the Press Daily program with Chuck Todd interviewed White House in the Senate after the hearing had ended. And after that interview with White House was over, Chuck Todd made the comment that of all the interviews with members of the Senate that I've done over the year, he said, I came to realize some time ago that the best legal mind in the United States Senate is Sheldon Whitehouse of Rhode Island. And I thought back to the statement that he gave midday yesterday. And that statement validated everything that Chuck Todd said about him. I want a copy of Sheldon Whitehouse's comments at the opening day, on the opening day of the Brett Kavanaugh hearings. One other thing that I wanted to mention, and it's the politics. This drove McCain crazy. It drives me crazy. Because each side is not talking to the other side. They're talking at cross purposes. What they're saying is going right by the audience for which it's intended, and vice versa. These people are making political statements and political speeches. They aren't communicating. They are pontificating. And I think it became clear. The hearings began yesterday morning, not long after 9 a.m. Eastern Time. By 10:15, a little bit more than an hour later, I was on Facebook, putting a posting on there, because I had heard 3 Republican senators make the same statement about documentation made available to members of the Senate Judiciary Committee in this confirmation hearing. And this requires that I touch upon a few facts. Most of you probably know this if you've been watching much of this at all. On Friday night, before Labor Day weekend, the Friday of Labor Day weekend, President Trump announced that he was exerting executive authority to make more than 100,000 pages of material on Brett Kavanaugh unavailable to members of the Senate for this hearing. Mostly, the documents rendered unavailable related to Brett Kavanaugh's 3 years in the Bush White House. During that period, among the things we'll remember was the debate that went on over waterboarding and over the degree to which the Bush administration was allowing violations of what many people believed were basic human rights in response to 9/11. Brett Kavanaugh was there. He was on the White House staff at the time. He was an attorney. He was an advisor. All the documents related to his 3 years of service in the White House, the president is keeping from the Senate Judiciary Committee under exercise of executive of his executive power to suppress. Also, early on the evening of Monday, Labor Day, the night before the Brett Kavanaugh hearing was to open, the White House released 42,000 pages of documents on Brett Kavanaugh. An impossible situation to go into hearings at 9 a.m. the next morning, having received 42,000 pages of data at 6 p.m. the evening before. So Democrats immediately began to request a postponement. White House made the point in his statement that the reason these people who are on the Senate Judiciary Committee are on it is because they have legal backgrounds. They are attorneys. Many of them were judges. And White House made the point that no attorney would go into court to begin to argue a case and represent a client when unbelievable amounts of potentially relevant material were just uncovered the day before. Every lawyer, White House said, would go into court the next morning and request a continuance from the judge in order to give them time to look at this new evidence. And there's no judge, conservative or liberal, that would not issue that continuance. Basically, what White House was saying, is that this behavior on the part of the Republican majority on the Judiciary Committee is unheard of in the legal profession, and as lawyers, they know it. And yet they are condoning it, which suggests, White House claimed, that this is a political process from top to bottom, that the nominee was selected not by the President of the United States, but by the Federalist Society and the Heritage Foundation. And the President signed off on their nominee. The implication being that this candidate has been given a check of approval by big money corporate interests that are behind this and behind the interpretations that are coming out of 5-4 majorities on the Supreme Court. And the appointment of Brett Kavanaugh would nail down as permanent that 5-4 majority. No more questions about Kennedy every once in a while going against the flow. The Federalist Society and the Heritage Foundation were in effect attesting to the fact, or affirming, that when it comes to Brett Kavanaugh, he would never go against the flow. It would be a dependable fifth vote on the Supreme Court. It seemed to me that that was so significant. But this is my point. The first 3 Republican senators to speak at yesterday's Kavanaugh hearings made reference to the same thing. And that is more pages of documentation on this particular nominee for the Supreme Court have been made available to the Judiciary Committee than any previous candidate for the court ever. That there is more documentation on this particular nominee because of his 12 years as a judge, because of the decisions he's written, because of the dissents that he has written. There's more information, public information, available on this particular nominee than ever if any past nominee. In fact, Grassley made the point that he's been on the Judiciary Committee for 15 such nominees. And this one, more than any others, has provided the most information on any of them. All of them said that. What they're, of course, trying to do is counter the complaints of Democrats that there's more than 100,000 pages of documentation being denied to the minority. I thought it was kind of interesting in this morning's hearings, in an exchange between Senator Leahy, the Democrat of Vermont, and the chairman, Chuck Grassley of Iowa. Basically, if they want a particular document, the majority will see that they get it. But if it's been labeled secret, they can't make it public. In other words, what Grassley was saying to Leahy is, you tell me which document you want, I'll see that you get it. But I can't let you use it in this hearing because it's been labeled by the security to make it public. So in a sense, Leahy's response to that is he's never been in a situation before when he has to ask the Republican majority what documents he can see, what documents he can't see, what questions he can ask, what questions he can't ask. The whole thing is absurd, it seems to me. It's not absurd when you realize that it's political. But if you try to tell yourself that it's not political because it's not supposed to be political, then you can't avoid the label of absurdity. You can't avoid it. The fact of the matter is, on the third time around for the Republican argument that the Democratic opposition is claiming and focusing on 100,000 pages of documents that they were not able to get. But the fact of the matter is there's more documentation available than has been available for any candidate in history before. Well, the fact of the matter is, and this is basic 101 logic, it's not the number of pages of the document, it's what's on them. I put a posting on Facebook to this effect, and I talked about the absurdity of that argument. That ultimately it's what's in a document, not how many documents there are. The example that I used in the Facebook posting that I put on yesterday was the following. I've been writing political commentary and getting it published in various papers. I had a number of items published when I was in Virginia, in Richmond, in the Richmond Times-Dispatch, which is the state newspaper in the state of Virginia. Republican newspaper, conservative newspaper. But over the years that I was in Richmond, which was from 1975 until 1991, it was just 15 and a half years. I probably had 7 or 8 pieces published in the Times-Dispatch. Since I came to Beckley, I've had well over 40, maybe more than 50 op-ed pieces and commentaries published in West Virginia newspapers, whether it be the Charleston Gazette or the local Beckley newspaper here or the Hinton newspaper in Summers County or whatever. But the fact of the matter is, even though I've probably had close to 100 articles published since the mid-1970s, only one of those publications got me fired. It was in Richmond in 1985. I have it framed in the studio right where I'm broadcasting from so I can stay here and read it. The title of the article was "Managers in Education, Are They the Problem?" And this is one particular paragraph of this article that the editors of the Times-Dispatch chose to pull out and highlight. And this is what I said this is in November, the 17th of November, 1985. I am a teacher. I manage only my classroom. I am finding, though, that I have less and less control over it, for I'm spending more and more time trying to fend off intrusions by managers and their checkers, whose raison d'etre is to render me more efficient and to convince those who check on them that their role in the educational process is more important than mine. They are succeeding on all counts. What I was suggesting, that the priorities in higher education have been reversed. We have lost our way. Let me put it into context. There were 23 community colleges in the state of Virginia in the 80s when I was there. With a few exceptions, most of them were losing enrollment. Fewer and fewer students were going to college, at least community colleges. The one that I taught in Richmond was having budget problems as a result of the decline in enrollment. And the same newspaper, the Richmond Times-Dispatch, had been running articles from the community college offices pointing out that it was probably going to be necessary to eliminate a number of teaching positions in order to balance the budget, because enrollment was down so significantly that the flow of revenue was bordering on the red. And because the state required a balanced budget, it was going to be necessary to eliminate positions. In the particular college that I was teaching in, the estimate was that that institution would lose 37 full-time teaching positions in order to make sure that the budget was balanced. That was the context which prompted me to write this article. I pointed out that in downtown Richmond, on 14th Street in downtown Richmond, one of the tallest buildings in the city is the system offices for the Virginia Community College system. It was 11 or 12 stories high. It employed hundreds of people working in the various offices to manage the Virginia Community College system statewide. And the point I was making in the article is that there were more people working in that building to oversee the educational system than there were teaching in half of the community colleges throughout the state. In other words, what I was pointing out was that education was no longer the priority of Virginia higher education. Administration was, management was, accountability was, counting students was. Whether in fact we were providing a quality education to students rarely got a tumble. So basically what I did in this article was take on the Virginia Community College system. This article appeared in the Sunday edition of the Register Herald. I had sent it in the same way that I had sent in previous articles to this newspaper. But this is the first one that elicited a call from the editor. And what the editor said to me is, A, we love your article and we want to print it. B, do you mind if we put it on the Sunday op-ed page as the feature article in Sunday's paper? And we've turned our artists loose on it. We're going to put some drawings on it. We want it to get attention because we think what you've said needs to be said. Needless to say, I was flattered, and I said, by all means, whatever you need. That was on the 17th of November. 2 days before Thanksgiving, the following Tuesday, I was fired. And I spent the next several months debating whether, in fact, I ought to go to court, blah, blah, blah. I won't go into that, because it was very difficult to prove that I was fired because of that article. But let's face it, I kind of know I was. My point. After that, after 1982, that I was ever required to take was interested in that particular article, not the other 89 or 90 articles that I had written. In other words, the number of publications didn't interest anybody, but that one did, because it had consequences. Back to the Kavanaugh hearings. As a member of the Senate Judiciary Committee, being asked to cast a vote for or against Brett Kavanaugh's nomination for the Supreme Court, I may have been given access to more than 1 million pages of documentation. But the fact that I've been denied access to an additional 100,000 pages gives me pause. What's in them? In other words, the fact that the president at the 11th hour slapped executive privilege on these documents so I couldn't see them makes me want to see them all the more. And from my own experience, I may have 100 documents out there with my name on them, but the one people are interested in is the one that had an important impact. And so every interview that I had to take ever took after that, people wanted to know about this 3-year gap in my teaching from 86 all the way up to 90. You know, what, 3.5 years. I mean, why weren't you teaching then? And I had to say, well, I lost my job. Well, why did you lose your job? And I said, well, the argument, the formal excuse, a reason I got was budgetary, in order to guarantee a balanced budget. But the fact of the matter is, less than a week before I was terminated, I published an article in the paper that received quite a bit of attention. Oh, well, maybe could we get a look at that article? The point I'm trying to make is the arguments being made in the Kavanaugh hearings are political more than anything else. They are being made to impact or affect the viewing public, not the other senators. They are not communicating with each other. They are talking past each other. Both sides. So when Brett Kavanaugh makes his opening statement and says the last thing we can afford to see is for our judicial branch of government to become political, is in fact closing the barn door after the horse is out, so to speak. Anyway, I couldn't resist, and I apologize for the personal nature of this, but as I was sitting there yesterday watching this, I couldn't resist sitting there talking to the television saying, make the point about the fact that it's what's in the documents, not how many there are. I can give you 1 million pages of paper that say nothing, but I can deny you one page that says everything. The fact that you have 1,000,000 pages to one doesn't justify not getting the one. So that's what we're dealing with. And I apologize for taking up the entire first hour on this particular issue, but I do believe that it's significant. What I'd like to do when we come back is deal with another issue that's getting a lot of traction of late, and it's the issue of impeachment. I'm hearing so much about it that I thought it would be a good idea to come back and to go back some and look substantively at the issue of impeachment, what the founders intended, as well as what it's become. But first, we're going to pause and take a 5-minute break. We're just beyond the top of the hour. It's 1 minute after the hour, according to my watch. We're going to pause and take a brief break, and then we'll be back for our second hour. You're listening to the Virtual Center for Study of the Constitution and Civic Responsibility. We're going to take a short break. I know that Agnes has some music queued up, but for the rest of us, it gives us an opportunity to get up and move around and exercise so take a deep breath or whatever, in fact, we might want to do. Please stay with us. We'll be right back.
Virtual Center for the Study of the Constitution and Civic Responsibility. Here's your host, Dr. Bill Obrien.
Thank you, Agnes, and welcome to the second hour of today's program here at the Virtual Center for Study of the Constitution and Civic Responsibility. Again, today is Wednesday. It is the fifth day in the month of September in the year 2018. If you are just joining us, welcome. We spent our first hour mostly on the two lead items in today's national news, of course, which are the Kavanaugh hearings and excerpts of the Woodward book that's scheduled to come out middle of next week, next Thursday, I believe, on President Trump, that contains some pretty juicy quotations. It's going to be a bestseller. The argument has been that Wolf's book on the Trump White House was a bestseller, but that this one will exceed it. And part of the reason is because who the author is. I mean, it's Bob Woodward, whose reputation for journalism is impeccable, which makes it much more difficult for the Trump White House to counter much of what's in the book. And reports from the White House are that the president is absolutely out of his mind. He's been tweeting all day about this book, and has even suggested that Congress needs to strengthen the laws on liability for publications like this. And of course, his implication is that Woodward's book is a lot of it is dreamed up. It's a lie. It's not true, et cetera, et cetera. And he ought to be liable for this, and we ought to be able to take him to court, and things like this ought not to be allowed to be published, and all of this other things. It's really interesting because Woodward made available to the public, to the media, an 11-minute phone conversation that he had with President Trump after he finished the book. And in that conversation, he lets the president know that on 6 different occasions, he made contact with people in the White House trying to get to sit down with the president. And it never got anywhere. And the president's response is, I didn't even know about it. Nobody told me. Then the president asked him who he had talked to. And one of the people he mentions was Kellyanne Conway. And the president said, well, Kellyanne's right here. Let me put her on the phone right now. And she got on the phone with Woodward, with the president sitting there, and did a fast shuffle around why she never told the president about Woodward's request for a meeting with the president. And she said, well, there were other things going on. It got in the way. It got pushed in the background. You know how those things are, type of a justification. But the fact of the matter is, the president paid tribute to Woodward and his reputation and said, you've always been known for your honesty and the fact that we could trust what you say. Now, of course, the president is on the attack. But anyway, we spent our first hour on that. We spent our first hour on the first day of the Brett Kavanaugh hearings. We're into the second day now where the real questioning begins. And for those of you who are still with us after our first hour, I want to thank you for staying with us. And for those of you who may just be joining us, welcome. I'd like to take on another issue, which I think is quite significant, that's getting a lot of attention of late, and it's the issue of impeaching the president. And I thought that this might be a good topic to close out this abbreviated weeks of broadcast by addressing. If we don't finish it, we can come back to it the first of next week. But I do believe that it's important to address. Also important is your ability to participate in our program. And briefly, I'd like to just run through the ways that you can access and communicate directly with us. The easiest, most direct way, of course, is to call into the Head On Radio Network studios and get on the air. That way you can share your thoughts not only with me, but with our other listeners as well. If you are a user of Skype, you can just go on your computer and type in on Skype, Bob Kincaid Horn, and that would get you directly into our studios, and Agnes will get you on the air immediately. or you can phone in. Just pick up your phone and dial either of the following two numbers. Area code 304 574 8178 or area code 304 640 2829. There are two lines. Either one of them will get you directly into the studios, and Agnes will get you on the air. If coming live on the air is not your cup of tea for any reason, but you would at the same time like to share your thoughts with us, I would love to hear from you. You can send your thoughts directly to me in an email. My email address is waobrien906@gmail.com, or you can communicate directly with me by going to our Facebook page, looking at any of the postings that are there, and in the comment box that follows each posting, if you click on the comment box, you can share your thoughts with me, because that comment goes directly to me. And then, depending on whether in fact it seems appropriate to put it on the air, I'd be glad to do that for you. The point is, we would like to know what you think and what you have to say about many of the issues that we deal with here on the Virtual Center. The issue that I'd like to address in this, our second hour on this Wednesday, is the issue of impeachment. There's a lot of talk about it from both sides of the political aisle. Republicans are building their case for the November elections, which now, I believe, as of today, yesterday, 63 days, I believe, to the election. Republicans are building their case and trying to make sure that they get the largest turnout they can of their base by addressing the fact that if the Democrats are successful in winning control of the House, then it's obvious that their first order of business is going to be to impeach President Trump. So the basis of their campaign is the following. If you are a supporter of President Trump, if you support the things that President Trump has been able to do while in office, then the only way to protect him is to make sure that the Democrats are not successful in their effort to get the House this fall. Democrats, on the other hand, have adopted the strategy, it seems, of trying to distance themselves from talk about impeachment, because they realize that the more we talk about impeachment, the more that's going to validate what Republicans are saying about us, and it's going to get a large Republican turnout. But the fact of the matter is, impeachment is on everybody's lips. It's on the president's lips. So the issue is the legitimacy of President Trump's pending impeachment, whether in fact it would happen or not. Some months ago, we dealt with this issue here at the Virtual Center. And at that time, I put together a piece which appeared in our local papers here. And my point was that it's important to separate impeachment from committing a crime. Most people believe, and at that time I was suggesting, that President Trump's objective in talking about impeachment was to convince the general public that you would be impeached for committing a crime. So President Trump's argument or defense was to try to make sure that he was never convicted of a crime. The issue, of course, during the Russia investigation for the past year has been the issue of collusion with the Russians. Whether, in fact, not only the Russians interfered with our 2016 election, because the evidence clearly suggests they did, in spite of the president's continual denial that, in fact, they did. But more important, whether, in fact, Russian interference in our 2016 election helped get President Trump's elected, and whether, in fact, members of the Trump campaign worked directly with the Russians to make that a reality. In other words, did the administration collude with the Russians? And the president has been insistent throughout the year, saying, no collusion, no collusion, no collusion. There's never been any evidence of collusion. And a lot of people are denying that. And the fact is, we don't know everything that Mueller knows. Mueller knows everything we know, but we don't know everything he knows. But the clear strategy of the White House for some time has been to suggest that impeachment and committing a crime go hand in hand. That impeachment is the penalty identified in the Constitution for violating the law. The implication being, if they can't prove you broke the law, then they can't impeach you. And the piece I wrote, and what we talked about some months ago, was the inaccuracy of that strategy. It is a deceptive strategy. Because the fact of the matter is, impeachment is political, not legal. And what that means is, you can be found guilty of a crime, but it's not impeachable. On the other side of that same coin, you can be impeached for something that is not a crime. In other words, the reality is that criminality and impeachment don't go hand in hand. I said that some months ago. In 2017, 10 months ago, Cass Sunstein, who's a constitutional scholar at Harvard Law School, he's one of the most highly thought of constitutional historians and scholars in the country. Cass Sunstein made the same point. And I think it's very significant. And that is that you can be impeached. A president can be impeached even though he's not convicted of a crime. But it goes the other way as well. Even though the president is found guilty of committing a crime, that's not necessarily an impeachable offense. So the issue is, what is impeachment about? What was it intended to be about? What did the founders think they were doing when they inserted the impeachment clause in the Constitution of the United States? The Constitution refers to impeachment based on bribery, treason, or other high crimes and misdemeanors, unquote. That's what the Constitution says. Bribery, treason, or other high crimes and misdemeanors. Generally speaking, it's the high crimes and misdemeanors phrase that has given people problems. it appears to be vague. What constitutes a high crime and misdemeanor? The reality is, and I find this to be particularly insightful, it's exactly the opposite of that. Originally, during the early part of the Constitutional Convention, earlier drafts of the Constitution only referred to malfeasance in office. I'm trying to find the exact statement of this. I apologize for the time. I'm having problems locating my. Find it in a second here. Here it is. Maladministration. Originally, the Constitution said that the president could be impeached for bribery, treason, or maladministration. Maladministration was a problem because James Madison was concerned about the power of the Senate over impeachment. As we are seeing right now, or as we perhaps know, when impeachment charges are filed, the impeachment trial happens in the House of Representatives. It's tried in the Senate. Madison was afraid of jeopardizing separation of powers. He was worried about a term, maladministration, because it seemed to give the Senate power over the court, over the presidency, that ought not to be there. In other words, it left it up to the Senate as to what maladministration was. Madison felt it was too vague. There were some members of the Constitutional Convention who didn't want impeachment in there at all. Their argument would be, who would impeach? Whoever can impeach has the power. They're doing some work in front of the house here. There's a water leak out there, and I'm going to close the window because they're doing some drilling. They got a jackhammer going out there. Basically, Madison was concerned about the vague nature of the word maladministration. At the same time, politically, he was trying to win over his adversary, George Mason. And it turns out that George Mason is one of 3 members of the Constitutional Convention who's there at the end but refuses to sign the document. Mason's principal concern was the lack of a Bill of Rights. But Mason was also a stickler for impeachment because he, along with Pinckney and others, Pinckney of South Carolina, Charles Pinckney, was afraid of an all-powerful president. In fact, Pinckney made reference to what he called an elective king. And so many members of the Constitutional Convention were afraid of the power of the president. They were afraid that the president would become a monarch, an elected monarch. Madison and Hamilton led the forces for a strong executive. They wanted a strong president. The only way that Mason, Pinckney, and the others would support the Constitution was if it contained the right to impeach. They felt that as long as the people, the Senate, had the opportunity to impeach a president, that was a limitation on the behavior of the president. So Madison was willing to support the idea of impeachment, but he was not willing to go along with the term maladministration because it was too vague. It was up to the Senate to define what maladministration was. And he was afraid that the process would turn political. In light of what's going on right now, this sounds bizarre, but it's true. George Mason is the one who proposed the phrase, other high crimes and misdemeanors. That phrase had historical meaning. 6 state constitutions included impeachment provisions in the state constitution. They borrowed it directly from the mother country, from British common law. The right to impeach was the right to prevent a monarch, an all-powerful king or queen, from having too much power. George Mason is the one that drew on the phrase, high crimes and misdemeanors. He proposed it on the 8th of September. The Constitutional Convention adjourned on the 17th of September, 1787. So what I did was go online and look at James Madison's notes of the Constitutional Convention, day by day. And what I found in my research is the following. Impeachment was discussed 3 times during the summer of 1787. The first discussion of impeachment occurred on Friday, July 20th. That's the day that the convention adopted the phrase bribery, treason, and maladministration. And it bothered Madison tremendously. The next time that impeachment was discussed was September 8th, when George Mason made the proposal to replace maladministration with other high crimes and misdemeanors, to go with bribery and treason. This is a statement from Cass Sunstein in an article that he wrote just a little bit more than a week ago, August 23rd of this year, 2018. Sunstein makes the point: if a president tramples on civil liberties, punishes dissenters, or pays no attention to the separation of powers, he can be impeached. If a president shoplifts, fails to pay his taxes, or cheats on his wife, he is not impeachable, unquote. This ties in with an article that Sunstein wrote quite a bit earlier, in which he raised questions about people's tendency to look at the impeachment of President Clinton in order to consider the grounds for the impeachment of Donald Trump. Sunstein, as a constitutional scholar, raises serious questions about whether relying on the Clinton impeachment is valid. Because his argument is that even though what Clinton did in the White House with Monica Lewinsky was horrendous, it was not impeachable in the context that the founders intended impeachment to be used. In Federalist number 65, addresses the issue of impeachment. And he says the following: the subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or, in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to the society itself. Translation of what Hamilton is saying: impeachment is a political action of removal. It is an act to be taken for bribery, treason, or other high crimes and misdemeanors, all of which fall under the category of violating the trust of the office or violating the will or the support of the people who put you in office. In other words, the way you live your life, what you do, does not constitute an impeachable offense, Hamilton is suggesting. This is the article that Sunstein writes on the Clinton impeachment. He said that a lot of people are invoking the Clinton precedent as a basis for trying to impeach President Trump. He points specifically to Bret Stephens of the New York Times, who in an article quoted Senator Lindsey Graham, who said in 1998 about Clinton in support of his impeachment: Clinton lied under oath numerous times. He tampered with evidence. He conspired to present false testimony to a court of law. We believe he assaulted our legal system in every way, unquote. So says Lindsey Graham. Cass Sunstein's interpretation may be so. Maybe he did assault our legal system in every way. But Clinton's conduct is not what the impeachment clause is about. To use the Clinton impeachment as a precedent for Trump would compound a grave constitutional blunder. It's something for both Democrats and Republicans to avoid. Impeachment is a political tool for political violations, a violation of trust, a violation of the trust of the people, of the voters, abuse of office, abuse of power, violating separation of powers. These are the kinds of crimes for which impeachment is a legitimate punishment. I'm getting confused in my documentation here, so let me kind of get my stuff together here quickly. Here it is. I mentioned that it had history. It had historical precedent. Edmund Burke, to Parliament, talked about high crimes as being punishable. Quote, not upon the niceties of a narrow jurisprudence, but upon the enlarged and solid principles of state morality, unquote. It's a violation of the people's trust that constitutes grounds for impeachment. That's what high crimes and misdemeanors are. It has specific historical meaning. That's why Madison accepted it over the term maladministration. It was maladministration that's vague. High crimes and misdemeanors, Madison knew, was not vague. Because at the time the Constitution was written, people knew what high crimes and misdemeanors were. They were violations of the people's trust in a government accountable to the people. And what that meant was a president could be impeached for violating the public trust. But there are certain things, like jaywalking, for example, or not paying his taxes, or cheating on his wife, or whatever, that while we think they may be horrible crimes, horrible things to do, they don't fit the definition of impeachable. Again, going all the way back to Edmund Burke, in a statement to Parliament, Burke makes the point that impeachment deals with the principles of state morality, not the niceties of a narrow jurisprudence. In other words, you don't impeach somebody because they broke a man-made law. You impeach somebody because they broke the fundamental law, which is the Constitution of the United States, which is the trust of the people. What that means is that the president has a vested interest in trying to link people's understanding of impeachment with the commission of a crime, because he knows that if he's not found guilty of the crime, then the people will know that he shouldn't be impeached. That is dishonest, because the president can be impeached for behavior that may not violate a particular law. On July 20th, during the debate on impeachment, July 20th, 1787, Gouverneur Morris talked about impeachment and said the magistrate is not a king, but the prime minister. The people are the king. It's crimes against them, against their trust, that warrants his removal from office. Gouverneur Morris, July 20th, 1787. Madison made the point that the president had a lot of different opportunities to betray the trust of the people. And it's for that that the people need to have a way to get rid of him from office. Here's what George Mason said on July 20th, 1787, during the debate on that Friday. No point. These are Madison's notes. So it's Madison's notes. It's Madison's account of what Mason said on the floor of the convention. No point is of more importance than the right of impeachment should be continued. Shall any man be above justice? Above all shall that man be above it who can commit the most extensive injustice. When great crimes were committed, he was for punishing the principal as well as his coadjutors. Let me repeat that sentence because I want to make sure that it's understood. This is James Madison speaking, telling us what George Mason said. So when Madison says, when great crimes were committed, he was for punishing the principal as well as the coadjutors, what he's talking about here is George Mason. What George Mason was for was punishing the principal as well as the coadjutors. In other words, not just removing the president from office, but getting rid of all the people that participated in the violation of the people's trust. There had been much debate and difficulty as to the mode of choosing the executive. Mason approved of that which had been adopted at first, namely referring to the appointment of a national legislature. One objection against electors, letting the people choose the president, was the danger of electors being corrupted by the candidates. Think about this. The degree to which those who vote for the president are corrupted by the candidate. This was a major concern of George Mason, and this furnished a particular reason in favor of impeachments while in office. Shall the man who has practiced corruption and by that means procured his appointment in the first instance be suffered to escape punishment by repeating his guilt? Mason asks the convention. That particular issue is one that we are debating right now about President Trump. The degree to which his election might not be legitimate. If the Trump administration worked in collusion with Russian interference in our elections, if anything was done to raise questions about the legitimacy of the president's election, then for that, George Mason said he must be impeached, because not to impeach him gives him the power to commit the same crime again. And again, I use the word crime inadvisedly there. It's not a crime. It's violating the trust of the people. If we don't remove him from office the first time, he'll do it again, is what Mason is saying. Madison says on September 8th, the debates of September 8th in the Constitutional Convention, the clause referring to the Senate, the trial of impeachment against the president for treason and bribery was taken up. Colonel Mason spoke. Why is the provision restrained to treason and bribery only? Mason said. Treason is defined in the Constitution, as defined in the Constitution, will not reach many great and dangerous offenses. What Mason is talking about is high crimes and misdemeanors. And that's why he proposes it on that very same day, September 8th. We've got to find a way to remove the president from office if he violates the public trust. That's what impeachment is about. And I'm going to be thumbing through. Hopefully I can lay my hands on it fairly quickly. not doing too well, and I apologize. I got stuff scattered all over the place here. I feel like I've got the million documents that the Kavanaugh hearings are talking about. At the convention, the Virginia Convention to ratify the Constitution, Madison raised the issue which we have, the issue that which we're dealing with in relation to President Trump. And I think I may have it here. I'm sorry, I don't. There's one point that I wanted to make about this issue, and it was in a piece written by Robert Reich, former labor secretary, if you remember, in the Clinton administration. Robert Reich is now a political science professor at Berkeley in California. Robert Reich is talking about impeachment as well, but he's talking about something more than impeachment. And this one is beginning to get some attention as well as the debate about the current president goes on. Robert Reich's position is, depending on what Mueller's investigation turns up, impeachment of this president may not be sufficient. Because Reich raises the question, if some of the evidence that's beginning to come forward now holds up, what we're going to find at the end of the day is that President Trump's election was not legitimate. And Reich said, if his election is found to not be legitimate, then impeachment of him is not nearly enough. Impeachment, Reich said, would remedy President Trump's high crimes and misdemeanors. But impeachment would not remedy Trump's unconstitutional presidency, because it would leave in place his vice president, his White House staff and cabinet, as well as all the executive orders that he's issued, all the legislation that he's signed. The only way to uphold the intent of the impeachment clause in the Constitution, in this case, would be to annul the Trump administration. And for those of you who are familiar with the term annulment, when a marriage, for example, in the Catholic Church is annulled, it is written off the records. Officially, it never existed. What Reich is saying is if President Trump's election is deemed illegitimate, then that means that his entire administration since his election is illegitimate. That means everything he's done, everything he's signed, everyone he's appointed is illegitimate. And the only way to fulfill the constitutional intent of the impeachment clause in the Constitution, in this case, would be to annul the Trump administration. Not just impeach him, but eliminate all of it. That's beginning to get some traction, that idea. Because this is the first time that we are confronted with an impeachment situation that may literally reside on the election itself, on the legitimacy of the election. If we're able to document intrusion into our election by a foreign power, and we're able to establish collusive behavior on the part of the administration with that interference in our election, then it raises serious questions about the legitimacy of the election. Let me be blunt. If you take Reich's argument for annulment seriously, if what he says about what the president might have done turns out to be confirmed and supported with evidence, then we are confronted with the issue of annulment. We would be confronted with the issue of everything that this administration has done and is doing is illegitimate also. I would suggest to you that if you take this argument seriously, if this seems to make sense to you, then the Brett Kavanaugh hearings should stop immediately. Because this president, with the legitimacy of his administration being seriously questioned, ought not to be empowered to appoint for life another member of the Supreme Court of the United States. And the document that I'm struggling to find is valid to this issue because James Madison raised this particular issue of the legitimacy of a president's election as part of the high crimes and misdemeanors issue. The founders, and this is according to Cass Sunstein, the founders sought to create a republic because of their commitment to self-government. The electoral process was sacrosanct. If a president procured his appointment through corruption, that's what the impeachment clause is for. Madison bought into this argument. Madison raised the issue at the Virginia Ratifying Convention of the link between violation of the rules of election and impeachment. What I'm trying to do here, and I can't lay my hands on that document right now. We only have a few minutes left in today's program. I don't want to spend it looking for a particular quotation or a particular document. I'll find it when we get off the air. But my point is this. It seems to me that James Madison spoke directly at the Virginia Ratifying Convention to the issue of a candidate's getting elected to office illegitimately. Nobody, as yet, I haven't heard anybody speak to this, addresses the fact that no less than James Madison himself spoke to the issue of violating the electoral process and coming into office illegitimately, and that is grounds for impeachment. Robert Reich takes it to the next step, which is annulling everything that person has done while in office because of the illegitimacy of his election. I would suggest to you that there's validation in James Madison for raising the serious issue that Robert Reich raises of annulling the entire administration. How many times have we heard people raise issues about impeachment and say, hell, we don't want to impeach Trump. At least we know what we got with him. If we impeach him, we're going to get Pence. And Pence is even worse because we can't get anything on him. He's clean, he's pure, and dangerous as hell. So people have seriously weighed whether in fact it's worth the risk to impeach President Trump for fear what you might get in his place. What that means is, even if we feel we have legal grounds to impeach the president, for political reasons, it might not be the right thing to do because of what we'll get. I would suggest that if you think that way and argue that way, you're coming awfully close to the annulment argument. That if you can prove beyond the shadow of a doubt that the election was not legitimate, and now we know that less than 1 million votes, 770,000 votes in 3 states, are responsible for the president's election. Wisconsin, Ohio, and Pennsylvania, as I recall. If there is demonstrated proof that election violations occurred in those states and may have resulted in the election of this president, even though he received 3 million popular votes less than his opponent, then in effect the election is not legitimate. If the election is not legitimate, then everything that the president has done since he was elected is not legitimate. And if that's true, then impeachment would seem to suggest that the people have a right to take appropriate steps. And maybe Reich is right. The appropriate replacement of Donald Trump with Michael Pence. That could be a cure worse than the disease. Maybe we're talking something much bigger and much deeper here. And if you want evidence that this is not coming out of the blue without precedent, you can go to the Virginia Ratifying Convention, because James Madison raised the same issue. If a candidate is able to manipulate the electors in order to get elected, what's to prevent that person from doing the same thing again? You've got to be able to get rid of it. All of it. Not only the person who did it, but the person who helped him do it. The coadjutors, he called them. That's pretty powerful stuff, I would suggest. I hate to say this, but we're at the end of our time today. We're right at the top of the hour. I want to basically hope that you have a wonderful rest of the week. I know that with these impeachment hearings going on, we'll have some fodder for discussion the first part of next week. Thank you so very much for your continued support of the program and the Head On Radio Network itself. So for Bob Kincaid and Agnes, and for myself, Bill Obrien, thank you so very, very much for your continued support. You'll never know how much I appreciate it. Thank you.